Good morning, everyone. Welcome to the Intellectual Property Breakfast Club. As you know, our topic today is what intellectual property issues are top of the mind for the 112th Congress. This is our first Breakfast Club of the year. And as you know, the IP Breakfast Club is run by broadbandbreakfast.com. My name is Sylvia Syracuse, and I'm the Marketing and Events Director. Thank you for coming out despite the weather report. We're here today because everyone wants to know what's going to unfold in the new Congress with regard to IP issues. And apparently, a lot of people want to know. It's shaping up to be a very hot year and one of many debates and hopefully resolutions. Broadbandbreakfast.com has made an effort to keep up with all of them and keep you informed on what's going on. Please join me in thanking our sponsors for supporting our IP Breakfast Club series, the National Cable and Telecommunications Association, and Public Knowledge. A reminder, you'll see there are surveys on the table. Please don't forget to fill them out before you leave this morning. Finally, I'll introduce Drew Clark, our chairman and publisher, who founded Broadband Census, our parent company, in 2008. He will be moderating this legislative panel today. Drew Clark, who's chairman and founder of BroadbandBreakfast.com, which is a news and events company building a community around broadband stimulus, a national broadband plan, and intellectual property. Drew has a long-standing reputation for fairness and depth in his reporting. Drew launched BroadbandCensus.com in January 2008 as a means of providing objective information about broadband speeds, prices, availability, reliability, and competition. So join us now, in thanking Drew Clark.
We're so packed in here, we have to kind of push each other around to get by here. But thank you very much for setting the stage here for our discussion. We're missing one of our panelists, but we've been told he's on our way, and so we'll save a spot for him on the end there. Let me introduce our panel so that we can really get into the topics at hand, which are what IP issues is Congress thinking about right now? And we ended up with a very California-centric panel. 4 out of our 5 panelists are from the Golden State, but we know there's a lot of interest not only in that part of the country, but everywhere about intellectual property. And our first panelist is Carolyn Holland, who's the chief counsel to Senator Herbert Kohl. She is staff director as well of the Judiciary Committee's Subcommittee on Antitrust, Competition, and Consumer Rights, chaired by Senator Kohl. To her left is Ryan Clough. Have I got that name right? Okay. Ryan is the legislative director, legislative counsel for Representative Zoe Lofgren of California. And he handles intellectual property, telecom, technology policy issues. Of course, Zoe Lofgren is from Silicon Valley itself, and so she has a longstanding interest in technology, patent, copyright issues. To his left is Jeff Lowenstein. Jeff's the senior legislative assistant to Representative Adam Schiff, and in that capacity, he's been the primary staffer of the bicameral Anti-Piracy Caucus. And so he's got a strong interest in intellectual property, copyright protection from your base in Southern California. So thank you for being with us, Jeff. And then finally, so far, we have Laurent Crenshaw, who's the legislative director for Representative Darrell Issa. And he's, of course, Representative Issa is the chairman of the House Oversight and Government Reform Committee. He's also one of 2 members of Congress who are patent holders, and I've just learned about the new patent pending device that Representative Issa has on the market. Maybe we'll ask Lauren to tell us a little bit about it, because it could have impact for our Broadband Breakfast Club as well. So, and then finally, I'll go ahead and introduce Neil Quittner, even though he's not here yet. He's the chief counsel for Senator Dianne Feinstein, and he has had 2 stints working with Senator Feinstein, handling intellectual property and other issues, both from 95 to 99 and since 2009. He also was elected to the Maryland House of Delegates in 2002, so he's a former representative. So I thought I would start with Caroline here to tell us a little bit about your view regarding the intellectual property and competition mix and balance. We were talking a little bit about some of Senator Cole's thoughts about how new technologies are opening up new opportunities. Could you just speak a little bit about that and what you're going to be looking for on the IP front this year?
Sure, and I'm glad you said my views. Just for the record, these are my views and not those of Senator Cole's. Certainly the Antitrust Subcommittee has always had been mindful of the importance of intellectual property and balancing both competition and protecting property rights, and the importance that protection of property rights and has for innovation, which is also good for competition. In terms of some of the more recent issues that we've dealt with, one is slightly off topic in terms of those who are the broadband followers, but for those who are following patent law in general, we have a bill that has to do with pharmaceutical patents and how certain agreements that are made as part of the Hatch-Waxman process for generic drug entry. And again, here balancing the importance of recognizing patent rights and the monopoly that they give to a patent holder, but also acknowledging that they're not completely immune from antitrust law. If a patent is used in a way that's anti-competitive, that requires scrutiny, and the Justice Department has recognized that patent law and antitrust law do intersect, and there's a role for competition. One thing I'd like to touch on where this again intersects is in the enforcement of copyright protection, specifically the Combating Online Infringement and Counterfeits Act. One of our interests recently in the Antitrust Subcommittee has been the competition that is coming, currently is somewhat nascent, but starting to develop in the online video market. We've seen a lot of competitors come out to offer consumers video programming over their internet connections. And as part of that, we need to protect the content that's being put out there. That will, we hope, foster the further development and new business models of offering video programming. But it's very important to make sure that video programming is all legal content, and that we crack down on those who are offering illegal content. So there's another area that we're looking at.
On that issue, particularly, Carolyn, what are some of the problems or just anticipating problems that might arise in terms of companies that want to offer content? Are they able to get the content they want? Are they running into any issues as they deploy that content?
Well, I think that's something that we're still looking at. Certainly there's a concern out there that that content holders want to make sure that their content is going to be protected. And so that is something that's certainly going to be relevant when they're deciding whether they're going to put their programming out on the internet or through some online service. There's another area of making sure that that's slightly off the patent topic, but more the competition side, that that content holders are not precluded or not discouraged from putting their content out online because of other pressures within the industry, coming from the distributors. That's something that we looked at in the context of Comcast, NBC a bit, and that we hope there'll be conditions put on that merger to ensure that development of content online isn't hindered by the combination of a distributor and a content owner.
No, I think it's important to get that issue in the mix too. Thank you for joining us, Neil. We appreciate you being here, and we've already introduced your extensive background on the IP front. Turning to Ryan, your boss has been a big supporter of changes to the Digital Millennium Copyright Act in previous terms. Could you give us your perspective on whether that's a live issue or not for 2011?
Well, I'm in the position now in the House of Representatives of representing someone in the minority, so obviously a large part of all these issues is us waiting to see what Mr. Smith develops in terms of the IP agenda for the House Judiciary Committee. That being said, I'm honestly, at least speaking for my boss a little bit, not sure how much DMCA changes are on the forefront. I think that, at least within the tech sector, some folks have been happy, at least with some of the rulings that have been made in the courts, and also some of the, at least some parts of the rulemaking that's come out of the Copyright Office. You know, that's not to say that there isn't dissatisfaction and, you know, on a wish list with, you know, changes to the Anti-Circumvention, with changes to notice and takedown to prevent abuse of notice and abusive notice and takedowns, and the effects, chilling effects it could have on free speech. But that being said, I mean, I think that, I don't know, I don't want to sweep too broadly here, but I think a lot of folks in the tech sector might say that at the very least the DMCA hasn't been quite as bad as they foresaw, even if there are some pretty substantial changes that in an ideal world they would make.
What are the top priorities that you see the House taking on the IP front?
I guess I speculate on two different fronts. I mean, certainly patents is a major issue and carryover from last Congress. As I think most people here know, there were discussions between the House and Senate about a patent reform bill. They did not ultimately produce a comprehensive patent reform bill. I think one of the questions we immediately face is whether or not a comprehensive bill should be the undertaking at this point. I think there are some other things that a broader range of stakeholders in the debate can at least agree are a good idea. Most importantly, giving the PTO more resources to hire more examiners, to reduce the backlog, to improve patent quality. You know, we have to deal with some issues related to diversion that have been thorny for a long time within appropriations politics, but I think that's a hurdle that we can overcome. And if we can achieve that, that at least could be measurable progress. I believe my boss, she doesn't think that that progress should be held up by all the other issues in the patent debate that have become, again, very, very intractable. And there was a lot of concern within Silicon Valley, frankly, about the bill that emerged ultimately in the process between Mr. Sessions and Mr. Leahy. And there's a lot of sense that actually, as much as an overhaul of the patent system is needed, there is progress being made in various fronts through the courts. Certainly this Microsoft v. I4I pending case in front of the Supreme Court could have a significant impact, as many cases have been on a wide range of issues over the last few years. And so given that, I think there's a lot of hesitance, at least among parts of the tech sector and certainly my boss, to proceed with a comprehensive bill that, frankly, it's possible may do more harm than good. Well,
Thank you for that overview. We'll come back to the patent reform issue shortly, as that is still a big topic here. Jeff, tell us a little bit about Representative Schiff's feelings on intellectual property. You've highlighted some of the work you've done on the Anti-Piracy Caucus. Tell us a little bit about that.
Sure, thanks. Well, Congressman Schiff, as you said, is the founder and co-chairs of the International Anti-Piracy Caucus, which is bipartisan, bicameral. He's co-chair with Representative Bob Goodlatte, who will be chair of the Intellectual Property Subcommittee on Judiciary, and then Senator Whitehouse and Senator Hatch on the Senate side. And the caucus was very active in the 111th and going back, and will continue to be active in a lot of areas. You know, clearly there's sort of the Leahy bill. I'm not supposed to call it Quake, I guess, anymore. But in the Senate, and that sort of, you know, sucked up a lot of the attention. But, you know, and there was less sort of legislative work, let's say, in the House on the topic, I would say. But, you know, the caucus tried to be very active on the sort of pushing for sort of the voluntary measures that, you know, my boss is a big supporter of intellectual property rights, you know, believes that industry can take, you know, among those was sort of talking to some of the payment processors, among them, you know, all sort of the big names and the ad networks and the search engines, to sort of ask that they take sort of what we believe are very reasonable steps that they can to sort of not sort of participate in and profit from the theft of intellectual property. And you know, so sort of asking them to adopt best practices. You know, one of the other big things the caucus does every year is hosts sort of a rollout of the special 301 report that the USTR puts together every year. So in May, you know, of last year, and I think of this year too, we'll, you know, sort of highlight the countries that were put on the watch list by the USTR, and this year for the first time put also 6 websites that we identified as being sort of big names in the world of piracy of intellectual property, and you know, and so that was sort of a new thing, and it was, I think it's been pretty effective, and sort of that concept of pointing out where, you know, websites are you know, profiting from the theft of intellectual property is sort of a little bit represented in what Senator Leahy has put together. So I'm sure there's more I can say about it, but I'll leave it at that for now.
Well, let's talk a little bit about COECA, or however we want to call it. Tell us about the motivation for that. Was Adam Schiff a driver in that process, or once he was presented with it, what was his reaction to it, and how has it been received on the House side?
You know, well, I'm speaking for myself. You know, we're obviously, he's very interested in it, and I'm very interested in it. We were not, you know, involved in the drafting or discussions over there in the Senate. You know, we're our own little world over in the House. But you know, he's really interested in sort of the approach. It's a very tough, thorny issue to do legislatively. I mean, for one, just the politics of it for one, but also just, you know, making a system that works for rights holders, that works for people who want to do legitimate things with content, which, you know, there's plenty of. So, I mean, it's tough, and I won't, you know, I wasn't in the room, and I don't want to, you know, represent, you know, what they were thinking when they had those negotiations, but certainly from our side, you know, we appreciate that, you know, there was a willingness to take it up and to move forward with it, and, you know, obviously it didn't finish the job last session, but, you know, they had a strong vote in the Senate Judiciary, and, you know, I don't think it's an issue that will go away in the 112th.
We talked at length about the search engines and the payment processors and the ad networks at our October Intellectual Property Breakfast Club, and certainly imagine this will continue to be an issue going forward. We have really reached out to lots and lots of members of Congress. I won't tell you how many people Sylvia and I reached out to here, but we really appreciate having you as our Republican on the panel. Please tell us what Representative Issa has in store and what he thinks are the key IP issues that should be driving Congress and an innovation policy.
Sure. Well, as the lone Republican up here, I do just want to say that, again, I'm speaking for myself and not for the congressman directly, but a lot of what has already been said, I think that my boss would definitely echo. You know, we are going to have to deal with patent reform and again, and I say again because, well, it's a topic matter that's been around for multiple Congresses now. There's been talk about it, and I think that one of the ways that my boss has looked at the issue in the past and hopefully can carry over in the future, and it really sort of echoes what Ryan was saying, is that if we can't get a comprehensive bill done necessarily, then that shouldn't stop us from dealing with the portions of patent reform where there's broader general agreement on, whether it's the fee setting issue, whether it's, at least in my boss's case in particular, the false markings issue, which became really significant in 2010, where you went from, I believe it was 28 cases that were filed in 2009 to about 600 or so that were filed in 2010. And there's at least, there was a good opportunity really to get it done, but you know, you hear from CBO basically, and CBO is really one of the main factors that prevented the bill from moving forward individually, that there was a scoring cost of about $12 million over 10 years. you think of, in general, the numbers that we normally associate with Congress, that $12 million shouldn't really be an issue at all, but somehow it was. But we've been working with CBO on tweaking the bill that we introduced last Congress so that we can eliminate the scoring issue there. Beyond patent reform, my boss being the new chairman of the Oversight and Government Reform Committee, I think is going to certainly focus on government IT reform. He and Vice President Biden had a meeting not long after the election, and that was really one of the top issues that they agreed that the administration and his committee could work on together. I think that there have been a lot of good ideas that have been that were issued, I believe, in the Chief Information Officer's report recently that at least provide a good starting point for all sides to come together. I think, cloud computing being one in particular that everyone's really looking at. But then the question is, when you're talking about cloud computing, does it just involve moving information from government servers to private servers, and are you really going to achieve much of a cost savings there, a cost benefit? So those are immediately, at least that come to mind, are some of the issues that we're going to look at right from the start of the Congress.
And I do have to give you a chance to tell us about your boss's background as an inventor, which he continues.
Sure. Well, my boss before coming to Congress was the founder and head of Directed Electronics Incorporated, which was an aftermarket automobile electronics company. So stereo speakers, car alarms, the Viper car alarm I think is what he's most well known for. At one point in time, he held about, I believe, 37 patents. I think some have started to expire, so the number's down to about 30 or so. And he, at least lately, has been very proud to go around and show his latest patent that he had, or prototype that he has a patent pending on, which is for a modified BlackBerry clip that is actually something that I think a lot of the women in the room would appreciate because it's made to be worn or clipped on, but not really interfere with, say, if you're wearing a skirt or if you're not wearing a belt. And it also has a pocket of some kind in it for holding credit cards and money. So it's sort of an all-in-one thing there. So.
Great. Innovation takes all shapes and sizes.
Absolutely.
Tell us, Neil, your perspective on having been in working with Senator Feinstein before and now again. Are the issues all the same? Is there anything new under the sun in IP policy?
There's not a lot that's new under the sun, actually. The false marking of patents issue is new under the sun. Senator Feinstein actually shares Congressman Iss's concern about the change in that was wrought by the Federal Circuit, and Lauren and I have been working together on some ideas to address the score issue because we're both going to be working on legislation on that front. So that's new. But in the category of what's the same, having worked for Senator Feinstein during consideration of the DMCA, then this past summer and fall working on COICA, I was struck during the COICA consideration how much it reminded me of the consideration of the DMCA. You have this sort of eternal struggle between content owners, copyright owners, trademark owners, and the user community. And I think that's sort of a perpetual and healthy dynamic, but it's not one that's going away. And we've certainly seen that at play again in COICA.
What about patent reform? What's your take on that?
Patent reform, I found myself nodding my head a lot when Ryan was speaking. I think that the comprehensive kind of patent reform that's been considered for the last several Congresses, just I think the fact that it hasn't passed shows how passable it is. It started off on one end, then it went to the other end, and it's a classic balloon problem where you squeeze here and another problem pops up over there. So just speaking for myself, I'm skeptical that it can ever pass. But I think what is passable would be some patent fee reform. And I think if you do patent fee reform with administrative authority for the PTO coupled with anti-diversion so that it doesn't become a tax on innovation, you will actually address probably 2/3 of the problems of the comprehensive patent reform is trying to address, namely patent pendency, the excessive time that it takes to obtain a patent, and patent quality. We've seen, obviously some pretty sketchy patents that have been issued, and I think that directing more resources to the PTO, keeping them at the PTO, can help address both those problems. And the courts are really dealing with a lot of the other issues that originally prompted the drive for patent reform.
Right, so separating them into the procedural issues and what needs to be done to ensure that the patent office gets the resources it needs, are there still, and you started to go on the pendency and the quality issue, are there still substantive issues to be addressed? And let's get some of the perspectives of other panelists on, has the Supreme Court already solved the patent reform problem by the series of decisions that's come down, including the eBay decision and others? What's the problem still on the table for those who, the substantive problem still on the table for those who want patent reform?
I will say, nothing that I said before is meant to say that there aren't substantial changes to the patent system that should be made in an ideal world. I mean, certainly my boss supported the damages reforms that came out of the House in the 110th Congress. There's improvements to the inter-parties process, and we could also create an effective, meaningful post-grant review process that could be a significant improvement. I mean, a lot of the provisions in past versions of Mr. Conyers and Mr. Leahy's patent reform bills are certainly things that my boss still views as, again, in an abstract world, very important. But given the political prospects that I think we're all sort of discussing here, she doesn't want to let those debates, and especially if those provisions, I think there's a recognition, at least among some folks, that doing something on and calling it a comprehensive bill but not getting the content right is actually worse than doing nothing. And given that, I think that's in part created the drive to at least address the resource issues.
Any other thoughts on the patent reform question?
I'm definitely not a patent expert, but I will say, just to echo some of the things Neil said, I think since Lauren talked and he didn't mention it, so I feel like I could mention it, is his boss, for example, had a bill which was co-sponsored by Mr. Schiff at the end of last Congress, and it's sort of along the lines of sort of more incremental changes that, can make some degree of difference, that was enacted, which is which basically creates a pilot for patent judges. Sure. And then it speaks to, we're going to go back and look, and over the course of this pilot, whether giving some judges more in the way of patent cases, or giving them the option to take more patent cases, and changes reversal rates we see down the line. I mean, so it speaks to this sort of patent quality issue, and it's definitely a very small, relatively small reform, but it is a sort of incremental process that you can make outside of the larger context of patent reform legislation.
Well, we'll hear what's on your mind in just one moment, but one question I've got, that no one here has mentioned the intellectual property coordinator position that has been created and funded, the IP czar, if you will, in the Obama administration. Is that going to have any long-term impact? What's your sense of what the administration is doing on the IP front and how that will interface with the legislative agenda?
I'll admit that, or I'll say that, the Obama administration, certainly on the IT side, has taken a lot of strides over previous administrations when it comes to integrating technology and really looking how it can be better implemented through the government. I think that the issue of the IT czar might end up falling into line with the issue of czars in general, which is something I think that is going to be addressed, I think, in a much broader manner over this next Congress. So it really sort of depends on, I think, how that falls into play with whether or not we end up with introducing, well, bills, I think Ms. Blackburn already introduced a bill dealing with the czar issue as a whole. And so it really will be whether or not the czars end up continuing to act in the same manner that they have. But I think from a general position, I think it's a positive step, and we'll, at least our committee, or my boss's committee, will work with them where applicable.
Sounds like something in Representative Issa's sights here. So.
If I could just say something, generally, I think that the importance of that position, that office, and what the administration is doing, and what Congress, bipartisan, is doing, is that in this economic time, we're looking at what is America producing, and one of the things that we produce is innovation. And I think that we've seen that across the board, and I think that's something that we can really all get together and get behind as just a big picture. Where are we going? What do we need to fix? And I think the IP enforcement coordinator has been helpful in, at least me as a staffer, having a resource to go to and having some place, one coordinated place where that's all done instead of going to each individual agency. So I think that does provide a benefit, and I think it's something that we can at least all agree is that protecting our intellectual property here at home and abroad is something that we can all work together.
Well, thank you for raising that important issue. Carolyn, on the back of my iPhone, and every iPhone and iPad and iPod, you see these words. It says, made by Apple. Well, I can't read it here, it's too dim. Originated by Apple in California, manufactured in China. So there's a kind of a message there, a very unique message. It's the innovation was here in the United States, in California particularly. The manufacturing has been outsourced to China, and so that's raising a lot of issues we hope to get to at our February event, which is China and intellectual property, and what are some of the issues that come up when so many U.S. companies are having so much of their manufacturing in China or in overseas countries. Any thoughts on that question from the panel here on how we make sure our trading partners respect American intellectual property rights?
Well, I suspect my boss has a slightly different perspective on this than a lot of the other folks on this panel, but it's not just a matter of protecting intellectual property. I mean, that's important, but one of the things you talked about, asking how we view the IP coordinator, I think my boss has some concerns, though it seems to be an ongoing process, about whether or not the administration considers the role of balanced intellectual property policy as opposed to just sort of a one-sided focus on enforcement exclusively as advancing innovation. I mean, advancing innovation is not just about focusing on intellectual property owners, though certainly that's important. It's also focusing on the effects of IP policy on intellectual property users, who also happen to be the innovators, certainly in Silicon Valley. And on trade policy, that certainly applies. I mean, again, the things that China is doing, that it's not just IP, it's not just a matter of IP enforcement. It's also a much broader range of trade policies that affect the IT sector that have, I think you could argue, given them an uncompetitive advantage over, or certainly an unfair trade advantages in attracting manufacturing jobs over there.
Okay. Any other comments here? Well, otherwise we'll go to the audience and see what questions you all have for our panel about legislative issues and IP issues before Congress. Sure. If you could identify yourself when you ask your question.
Hi, I'm Mark Donahue. I'm a trademark attorney with Eric Pelton & Associates. I was just wondering if any of you foresee any trademark issues on the horizon in the next year. For example, in March, the administration is going to be bringing to Congress, I guess, a congressionally mandated report on the effect of abusive trademark litigation practices on small businesses. Are any of you involved with that or following any other trademark issues?
I mean, I will say we've talked about COICA with respect to copyright, but the COICA legislation actually covers trademark infringement as well. And California certainly has a number of businesses that have been tremendously affected by piracy of their trademarks. And there has been some discussion, I don't know if it's going to go anywhere, but of extending the notice and takedown model that the DMCA established for copyrights to trademarks. It would have to be adjusted because they're different regimes, but it's a notion that has received at least some discussion.
Oh, thanks. That's a good point. how the notice and takedown notion, is it a viable one? Is it working? Are internet service providers happy with the responsibilities they have? And feel free, if anyone has any other thoughts on it, to weigh in.
Just on a different trademark topic, one that has been working its way through the courts that we've noticed as something of interest is the use of trademarks in online ad network and purchasing trademarks for purchasing the trademark name for online advertising purposes. Just something that has been of interest, and we know that it's working. Some of these cases are working their way through the courts. Been looking at.
In general, though, in the U.S. law, as I understand it, you're able to use a competitor's trademark in your metadata. Is that an issue that would be, would Congress and the tags, when you would want to do a search for American Airlines and your Southwest airline, has that reconsideration of that issue come up at all? Or is that what you're thinking of, or is it something else, Carolyn?
It's not something that we're thinking of addressing,
Yeah.
whether Congress could even do that, but it's something that's on our radar screen, certainly from the standpoint. The subcommittee has long looked at internet advertising issues, and it's just an internet advertising issue that came to our attention that we're aware of, and all folds into the mix of competition in the internet search space.
Okay, great. I'll work my way back, because I know we've got many questions.
Hi, I'm Jennifer from Politico, Jennifer Martinez. 2 questions. One, how likely is it for the House to introduce a companion bill to the Leahy one this year? And then also, have any of your congressmen expressed concerns about ACTA, which is likely to be taken care of in February, and that's an executive agreement, and I don't know if any of your congressmen are going to be weighing in on that trade agreement.
In regards to a companion bill to the Leahy bill, I would say, well, again, speaking just for myself here, I think it's very likely that you will see a companion bill done. I think it's one of the top priorities of Chairman Smith is to get a more comprehensive version of patent reform done, and I think it will be very different from the bill that was introduced that was introduced within the last Congress. I think that
Jennifer, were you asking about the Leahy bill on the COICA? Is that right, and not the patent reform?
On copyright.
Yeah, the counterfeiting, the combating online infringement, and help me out here, somebody. Counterfeiting Act, yeah.
Forgive me. My own personal opinion is that I think we'll hold hearings on it, in relatively short order, but I don't know if we're necessarily going to move as quickly on COICA as the Senate side did. I think that there's still a lot of unanswered questions that I think members in the House will want to really dig deeper into before acting on it.
And how about the ACTA issue, the anti-counterfeiting trade agreement? Anyone?
Sure. I mean, my boss has, over several years, weighed in with concern with the administration over this. I mean, precisely because this agreement was negotiated largely without transparency and also designed to avoid any congressional, basically, oversight or input. And so I think that, the latest draft that we've seen has made some improvements given compared to past drafts. There's still some concerns. I think overall, we're starting to see now talk of the Trans-Pacific Partnership negotiation, also including some pretty significant intellectual property provisions. I think there's some valid concerns out there about using trade agreements to affect substantive copyright law within different countries, and the implications of using those processes for that purpose. And also, I just point out that even when you're not talking about changing United States copyright law, when you export certain portions of U.S. copyright law without also including the limitations, exceptions, et cetera, then that has an effect on American companies operating in those other countries where we export those law. And again, to get back to my earlier point, it's not just about protecting intellectual property, it's also about considering the flip side, how intellectual property overall affects innovators across the spectrum, both content and technology providers.
Okay, thank you.
Let me-
Please, go ahead. Go ahead while I walk back.
Really quickly say, well, just on the first question, I mean, I think it's hard to make predictions, but I would bet, in my personal opinion, you'll see some sort of companion, maybe not identical, but there is a lot of interest in this issue, enough so that I suspect someone will sort of take up the mantle. And my boss probably has a little bit different take on some of on ACTA and the TPP negotiations, and more generally, part of the International Anti-Piracy Caucus is, has pushed sort of over the course of ACTA's negotiations now with TPP and elsewhere, sort of for strong, intellectual property protections in international agreements, and sort of using the U.S.'s trade power, if you will, to sort of push countries that are not taking intellectual property as seriously as we would like to do more. And so, so ACT is obviously along those lines. Without getting too deeply into the weeds of that, there's some support for that as well.
Great. We have a question back here.
Hi, Dan Brenner, Hogan Lovells. Right now, there is a undecided copyright question of whether companies like IVI, which is a Seattle-based internet company, is allowed under the secondary transmission rules of the Copyright Act to retransmit and transmit broadcast signals by simply claiming that the compulsory copyright covers their use of the signal. It's in two courts right now, but it seems to me that either they can or they can't do it. It's not. It seems either the law intends to cover that and it doesn't, and the implications spill over to all television, because today cable and DBS companies pay for those signals in addition to relying on the compulsory copyright for the underlying IP content. And IVI has taken the position that they do not have to negotiate with broadcasters for those signals and are entitled under the wording of the statute. Have any of your offices decided who's right in this dispute?
No.
Yeah.
It's something that we're following and that we've looked at, but no.
Well, the issue of the compulsory licenses comes up not only in the television, broadcast, cable context, satellite context, but it also comes up in regard to music, or at least it used to, and I think still does. One European company, Spotify, has had a lot of trouble getting into the U.S., and there's always some question of, can they get the content they need? Is a compulsory license necessary in the music space? Does anyone have any thoughts on different licensing schemes when it comes to the music world?
Excuse me.
Did you want to comment or not? Probably not.
I mean, I would just say that, yeah, certainly my boss thinks, again, but I think we're talking about completely the abstract, that yes, in an ideal world, we would need to take a serious look, and it'd be a good thing to explore some innovative ways to potentially use compulsory licensing to promote new business models within the music industry, but I wouldn't say that that's actually on anyone's near-term agenda.
Right. Well, how about television, Carolyn? Let's just come back to what are the things that Senator Cole has been thinking could be levers to promote greater choice and competition in the video marketplace?
Well, certainly something that that we raised in the context of Comcast NBC was carriage, and whether some level of the program carriage rules should be extended to the online space. I think that's an open question, something that we're looking at and that we're interested in, but certainly an open question, and maybe we'll have a little more clarity where the FCC is on that when they come out, when we finally see their conditions for that merger. But that's one area where people are talking about.
And how does the net neutrality rules of the FCC affect this discussion? Any overhang between the broadband issue and the copyright issue?
I mean, there always is. I mean, certainly, from the beginning, whenever you talk about broadband, copyright tends to sort of work its way in there, and especially now that so many people get, everything they consume, in terms of video, music, so on, through the internet rather than through, television or broadcast or cable or whatever, it always is going to sort of work its way in, and it's not I mean, I'll just say this is very vague, but it's not an easy thing to deal with. But from my boss's perspective, from Mr. Schiff's perspective, there sort of has to be conversation along the way of, well, as these, just as technology changes, are we sort of putting in place a regimen that we can continue to protect people's intellectual property? And a lot of it is done most effectively through sort of voluntary industry best practices, and you see that really across all these spaces, I think.
I mean, I'll just add to that I think if you care about net neutrality and you care about the rules that the FCC just put forward, there has been a lot of discussion about what the exceptions and limitations on those rules mean, and one of those would be what it means to allow companies to block or degrade service to unlawful uses. Certainly one of those could be for the purpose of copyright enforcement or limiting infringement or something like that. So of course the devil's in the details here, but I do think there's some concern, my boss certainly shares it, about whether or not companies will use the name of copyright enforcement as a way of skirting those rules.
Oh, good question. Who else would like to ask a question here about our panel? Go ahead and keep those hands up so I can see them.
Hi, I'm Tony Dutra with BNA. You talked about the intractable problems in patent reform. Could you identify a couple of things that you believe are intractable, the provisions that were in the last Congress?
Well, I'll jump in here. I think that the large tech companies have a continuing interest in damages reform, and I think Senator Feinstein's obviously very supportive of the compromise language, gatekeeper language on damages that she played a key role in brokering in 2009. I think that's sort of a standoff. I don't think that the large companies are going to lose their interest in that, but I don't see the Senate at least budging off the compromise that we struck last time. I also think that the issues surrounding post-grant review are politically, in the sense of legislative politics, not Democrat-Republican politics, but are politically difficult to ever address because, the user community wants to be able to make it easier to attack bad patents, but the inventor community, the universities, the fledgling startup companies, small companies, their few patents can be are their lifeblood. So they're going to guard the ability to maintain the integrity of those patents very, very jealously. And I think that's another area that can be pretty intractable to get something that could pass both houses.
On the patent reform front, there's this big picture sense that it's the technology sector, information technology sector that's wanted to get change in this direction, and the pharmaceutical industry that has not wanted that. Could you just comment on that simplification?
Yeah, because I'd heard that before too, and having been involved in the issue for the last year and a half, I just think it's just a gross oversimplification. I mean, it's so much harder to break down the interests in patent reform than by saying, well, this sector likes this and that sector likes that, and it's those two sectors against each other. I mean, there's a whole range of companies in the economy that don't fall into either of those sectors, and they split all different ways on these issues. You have a large company, small company dynamic, even when it comes to information technology, and I think that that's just too gross an oversimplification.
Well, but what about the recent court decisions? Which ones do you think have helped to address the problem, the perceived problem that's some have been promoting patent reform as a solution to?
Well, I mean, I think Seagate formed a template for the gatekeeper compromise on damages that was very helpful. I think there have also been some decisions on venue that have been helpful there too, for example.
Yeah, good. Okay, we have some more questions in the back. I'm going to just, since we're so crowded, go here, because we have plenty of time.
Okay, this is kind of a follow-up question. Sorry, Chris Norton with Law 360. This is kind of a follow-up question to the last one. Yeah, we've talked a little bit about some of the intractable problems that have kind of prevented a comprehensive bill on patent reform from getting through. I was wondering if you could go back over, or maybe even just restate a couple of the things that you thought there is broader agreement on. I think we talked a little bit about the fee structures as one of those things. Also possibly, I don't know, I'm interested in what else you think, in addition to the fee structures, you think there could be more concrete action on absent a comprehensive bill?
I'll throw it out there, and again, I think most of these fall in the category of pretty minor improvements relative to certainly something like damages reform, which would be a major enactment. But third-party submissions of prior art during the examination process at the PTO, I think that would potentially help. I mean, again, I'm mostly listening to some patent lawyers here. I'm certainly not a patent expert myself. That's just an example. I think most of these things fall into the category of focused on PTO process.
Great. We have, oh, sorry, go ahead, Laurent.
Also, what I mentioned earlier about false markings, just dealing with the solution to that situation that really arose at the end of 2009. As Neil mentioned, both Senator Feinstein and Chairman Issa have been working on, and we both have been working on options there to really, probably mostly dealing on the QI-TAM side with limiting the ability of lawsuits to be filed to those who've actually suffered a competitive injury, rather than how it's currently written, where any person's allowed to file. And that's I think another issue, because you've had, as I said, about 600 cases filed, and while most have not actually gone to trial, companies have preferred to settle rather than actually bringing it forward. It's still, I think, it'll continue to be a problem, I think, for years to come, given the two cases. I think the Solo Cup case was one that were decided. So that's another area I think that we really that we see as one that's a rather easy fix, and the comprehensive bill that Senator Leahy introduced last Congress, I know, had a fee offset, I think, to deal with that. So whether or not we go that route with it being in the comprehensive or move it separately, that's another area as well.
I'll throw fee diversion in there too. I mean, I think, because it's one of these, it's a really important issue. It's something that you don't, but it's also something there you don't see sort of industry or intra-industry fights about. It's more of an intra-Congress fight between sort of appropriators and authorizers about how we go about funding an office like PTO that takes in so much through fees, which doesn't make it easy, but probably makes it easier and to solve. And I think we go, as I think Neil said earlier, we go a long way towards sort of solving some of the general issues with patent quality and patent pendency that have been around for a long time.
No, that's an excellent point to raise there. We had two questions. Did you have a question?
Yeah. My name is Elizabeth Sweezy from Fairwinds Partners in Cadna. My question is, to what extent, if at all, have your bosses or your offices addressed the ICANN issue with regard to trademark owners and cyber squatting?
Anyone want to take that?
We haven't gotten involved. We're following it.
Yeah. Same. It's about the
So, just could you elaborate a little bit? What is?
ICANN is the governing body of the Internet Committee of Assigned Names and Numbers, and there have been some oversight concerns whether or not this supposed nonprofit is actually acting in a nonprofit way. They're also getting ready to launch an unlimited number of TLDs, which is the extension after a domain name, and the root, and then .com is an extension. So I don't know if you guys heard of .xxx or .nyc or .shop or .store. those sorts of names are going to be up for application, and then if there are more than one applicant, auction situation. Anyway, I'm just wondering, does anyone else in the room have any knowledge of this at all?
Well, I know that the Commerce Department periodically has weighed in, but I'm not up to speed on the latest. So if anyone has, raise your hand and we'll get you as a question. Okay. All right. We'll come right back to you in just a moment, okay? So let's get another question here and we'll circle back.
Hi, Megan Gray of Gray Matters. I have 2 questions. First, where in the queue, if at all, does Orphan Works legislation and fashion design legislation fall? And secondly, do you anticipate that there's going to be funding provided for Victoria Espinel's IPEC office so that she can actually hire a person?
I think that fashion design legislation, Senator Feinstein was just involved in that, in the past month. I do think that is going to be around. That was on my list if I ever got the open-ended question of IP issues that I thought would come up in this new Congress. I do think the fashion design legislation will come up, and frankly, I don't know where the House stands on it. I think it is possible to get it through the Senate, though.
How about
I also had Orphan Works on my list. I think that's a possibility. I don't think there's a lot of activity around it, but I would put it in the, also put that in the, I would put that in the possible category.
Please, Carol.
On Orphan Works, I think we're all also very interested in seeing what the Second Circuit does with the Google Books settlement. I think it's maybe even coming up on a year since they last had the last oral argument about it. So certainly we'll be keeping an eye on that.
Is it fair to say that the Google Books case has kind of put that off, the Orphan Works, because there seemed to be a lot of consensus around that legislation just didn't get over the finish line in either the 110th or 111th Congress?
I'm not sure what Senator Leahy has planned for that or what his strategy is, but from the antitrust subcommittee's perspective, we've been very interested in seeing what happens with Google Books. I think that will impact potentially what the legislation going forward could look like.
I will add one thing to that, which is certainly Orphan Works is very related to Google Books, but I'm not sure that digital libraries, they entirely overlap, in that if you had an Orphan Works proposal like came up in, I believe, the 110th Congress, that would really make viable a digital library like Google Books. There are some other problems in dealing with rights clearance, and especially the economics of how you clear the rights for an orphan work in terms of that proposal that wouldn't necessarily be solved within broader Orphan Works legislation as applies to illustrators and all kinds of other works.
Okay, let's go back to ICANN for a second.
Yeah, I understood your question, and my name is Derek Kahn. I'm from Senator Scott Brown's office, and I think ICANN is really critical to looking at the internet as a whole. But my question was specifically about ICE and ICE's operation. I think it was Operation Takedown. And then Takedown 2. They've had a whole bunch of these operations to bring down websites, and they put up their whole little emblem on the website. And so my question to you guys is do you think that this is something that needs to go forward? Is ICE the most appropriate mechanism to do that? Why hasn't this hit some of the bigger providers? It seems like it's just hit some of these small guys as opposed to like Pirate Bay or some of the big guys. And lastly, how does this fit into ICANN? There's been a lot of threat that it could lead to a splintering of the internet where you have, excuse me, it sounds a little bit crazy, but the idea is that you have a separate DNS server so people are no longer using ICANN registry in order to access their website. So these sites are still available, but on like the black internet, if you will.
Taking the last point, that was actually an issue that Senator Feinstein raised at the markup of the COICA legislation. She is concerned about the domain name remedy in the COICA legislation. A lot of people have made a decent case that the Internet Gambling Prohibition Act, which goes after the credit card companies, is relatively effective, and that you could take that same approach to pirate websites without going after the domain name itself, because you could get those unintended consequences. There was, we received that letter from 89 engineers and lawyers and others in sort of designing the standards for the internet that raised those concerns, which I think got Senator Feinstein's attention at least. And I think on CORCA we're going to be having a hearing, not we broadly, that I think the Judiciary Committee will be having a hearing before the legislation gets considered further, where we can kind of get further into these issues.
I would echo that and say, I don't know that there's a way addressing these things through ICANN, through DNS, that you're not going to run into the same sort of problem with, like I mentioned earlier, this watch list that we put out, and one of the sites on there is based in Luxembourg, and the name I'm going to botch if I try to get it, but they were sort of directing people to a lot of pirated music, and that was actually one of the sites that was taken down in the operation you mentioned in November. So if you go to that site right now, the ICE symbol pops up and says the site's been seized, but if you Google it, you can fairly quickly find the new place where it's popped up under a different name. So you always are going to run into that sort of whack-a-mole problem. That said, my boss certainly supports what ICE is doing and being aggressive with that. And just also, again, as Neil said, there's the sort of the payment processing side, because these people, a lot of sites are out there to make money more than anything, more than to sort of make a point about copyright. That they want to make money from people who want to download the music. So we can, that is sort of a way of getting at them.
Let me just interject here. On this issue of ICE taking down sites, what is it that COICA is designed to do to enhance those powers? Like, what's the problem that COICA is solving that's not addressed by the capacity that DHS has right now to take sites down?
Understanding that it would transfer really to the Department of Justice. So basically, if there's an issue that's found, if you find that this site, wherever it's based, is violating copyright law, that you can notify the Department of Justice, and then they can take the necessary means of bringing it down. Whereas right now, what DHS is doing, what ICE is doing, is really going after sites that are based outside of the United States, and using sort of the customs and issue, basically that transaction that's occurring with the download to an ISP within the U.S. And those are really the main differences there. So it just gives a broader authority, that certainly for DOJ to go after it, but at the same time, then it raises the question of whether or not DOJ is really put in this position where they're sort of policing all of the basically all of the all of the internet in some ways, which I think is one of the difficult issues to address there. And I think really sort of going to the issue of the separate DNS servers, I think that's really sort of an inevitability anyway. In some ways, you already have countries like Iran and China and DNS servers outside of the normal ICANN domain names, and I think it's really an issue of well, I think whether ICANN, if there's anything we can do to really even stop that, right. And if we currently have the necessary means in place of going after the violators that are moving to those the black market servers, so to speak.
It becomes a foreign policy issue.
And the other thing that CORCA does that goes beyond current law is that it gives you the ability to go after the service providers, the payment processors, and the ad networks, which I don't think there's that ability right now in current law.
If I could just add, I mean, that's exactly, I think that's one of the reasons why at least my boss has concerns about it, is because as opposed to the present seizures, which were enforced directly on VeriSign, the domain registrar located in the United States, these are enforced on intermediaries. And so it's a pretty dramatic expansion of enforcement on and actually censorship on intermediaries. And the only other thing I'll add is that I think that the New York Times articles about the domain seizures certainly caught my boss's attention in terms of pointing out some of the risks and uncertainties about domain seizures. I mean, you have in these a wide category of sites, some that were very clearly bad actors, but others that it's not so clear how active or contributory their infringement was, especially when you're talking about music blogs that linked to some files that may have been provided by the content companies themselves for promotion purposes, and then all of a sudden they get shut down by ICE and DOJ without any ex parte proceeding, no notice, no due process, basically, except for a magistrate signing off on a seizure warrant. So I think it raises a lot of troubling concerns that implicate core First Amendment issues.
Okay. We have one more question here, or at least one more question here.
Actually, it's a comment on the last question. I'm Jim DeLong with Digital Society, and that is COICA would also have has a provision that encourages voluntary action on the part of the payment networks and not the service providers, but the domain names and the payment networks. And that's a fairly significant change in the law.
I mean, one of the things that payment processors worry about with taking action under current law is that they might be exposed to lawsuits from people who, if they say, well, we're not processing, MasterCards are not processing your transactions anymore, I mean, they turn around and get sued, and they don't have sort of a safe harbor to do that because there's no, you might be able to point to that site and say it looks like they're, involved solely in piracy, but, it's not always that cut and dry, and there's no government, law enforcement sort of stamp on that action. So, there is that concern, which is, I think, part of the motivation behind some statutory changes like COICA.
We've been talking here about the ICE, the Department of Homeland Security, and DOJ issues. I want to come back to the administration for the last couple of minutes here. There was a question that I don't think we really got a full answer here on funding for the IP czar. Is that an issue that Congress would be supportive of or not? But also, let me just interject. This is the first administration that has hired a chief technology officer. The administration has done lots and lots of new websites that are much more dynamic than previous administrations. So there's a lot of attention, one hears, to technology and improving technology. There's a national broadband plan put forward by the Federal Communications Commission. Who is driving the Obama administration's approach to technology generally, but IP, which is, of course, a key aspect of that? Do you all look to DOJ or DHS or this new coordinator? When you all want to know what the administration's position is, who are your bosses calling?
I don't know that it's like one or the other. I don't really see it that way. I think the administration has a lot of very good people on these issues, and some of them are probably in all of the agencies you mentioned, at least in my experience.
I think it goes back to how President Obama was elected in the first place, which you can argue focused very much on getting the support of basically numerous individuals who are really tech savvy, and I think that that's carried over into his administration. I think that, to your point on the IP czars, I go back to what I said earlier, though, and I think that it's really, when talking of funding the IP czar, I think that it will still be an issue, at least on the House side, of whether or not the IP czar gets caught up in the issue of czars from a larger standpoint, I think, which is something that is going to be focused on by a lot of people within Republican leadership. I know our committee is certainly looking at the use of czars and really just looking at ways of addressing the issue so that at least at some point in the future they have to go through a confirmation process of some kind rather than simply being appointed.
Well, she did go through a confirmation process.
Sorry, well, but I still on the general funding of it, though. I think that it's something that at least conceptually, we do support, right. Absolutely, but I think it's just whether or not it's the best process to go through right now. And I think that, we'll really, to your final point or question on who we've talked to, right. We've started from as I mentioned before, with Vice President Biden and really laying out from a broader stance of how we want to go about it. And so,
okay.
Looking at reform.
What did the Senate side people think, Neil?
I mean, I think traditionally administrations don't really get involved very much in IP issues. And I actually think that that's one of the things that the Intellectual Property Enforcement Coordinator could be changing, because oftentimes in government you have these silos where justice is doing this and commerce is doing that, customs is doing this other thing, and the White House is tasked with managing government and bringing it together. And I think we see some of that developing with the IP enforcement coordinator, where she is looking at, what can be done with our embassies in combating piracy that originates overseas, what needs to be done with justice, what needs to be done with customs. And I think in the relatively near future, you're going to see some legislative proposals coming out of that shop, which I think, just regardless of the merits of the proposals, the fact that they would be coming out with legislative proposals is a step beyond what has existed before that office was created.
Okay.
The funding battles is one of these things that just remains to be seen. It's just crystal ball kind of stuff.
Yeah. Well, especially now we've got a Republican House and a Democratic Senate. Carolyn, did you want to add to that point about the Senate's perspective on the IPSR, funding of the IPSR?
I mean, I'm not sure. I'm not going to try and predict anything about funding in the next Congress, but I think she has. I think their first report was released in June, and I think there's certainly a very legitimate and relevant and useful purpose that she'll serve. But I almost want to throw the question out probably to the people in the audience. I think that it's also a place where where industry can go to one person in the administration, which I think is another useful role for her to play. But I'll leave that to the folks in the audience to judge, because a lot of times we hear from industry, and since IP enforcement crosses many agencies, to have one point person to go to in the administration, I think, is useful.
Yeah. We have time for one or two more questions, if there are any. If not, I'd like to ask one last question of our panel, and then invite them to each give their prognostication for what's most likely to happen in the next 90 days to 6 months. The Register of Copyrights, Mary Beth Peters, is just retired, and so there needs to be a new Register of Copyrights picked. That falls within the Library of Congress, which is, of course, the legislative branch. I'm wondering if any of you have any thoughts on this peculiar arrangement where the Library of Congress and the Copyright Office are a legislative branch function and not an executive branch function. That's my own little question for you, but I do invite you to add any other topics that you'd have that you think are going to come down the pike. And let's start with Neil and go down this end, if you don't mind.
Well, I just want to, I see that oddity, but I don't think Senator Feinstein's really taking a position on that particular question. But I did just want to bring up one other subject which I'm a little surprised has not come up at all today, which is performance rights legislation, establishing a performance right in broadcast transmission of sound recordings. I do think that is something that the Congress will be involved with in the new Congress. It's an issue that's important to Senator Feinstein. It's an anomaly. America is an anomaly in not providing this compared to the other industrialized nations. I think we're the only one out of the 20 most industrialized nations that doesn't provide that. And I think it also addresses a disparity between, a competitive disparity between internet radio, satellite radio, and broadcast radio, where internet and satellite have to pay a performance royalty, but broadcast doesn't. And even in there, internet and satellite have different standards for how that royalty is set. So Senator Feinstein would like to see, a fair, more level playing field where everybody pays a royalty and the royalties are comparable. So even within the performance rights legislation, there was negotiated, for example, a small broadcaster fee structure with tiers based on the size of a small broadcaster, and she's supportive of having small webcaster parity with comparable discounted fees, for example. So I wanted to raise that.
No, thank you. That's on our March 8th program, but appreciate you raising that. Very good. Lawrence.
I think that within the next, well, to your first point for the copyright.
Don't feel compelled to address it. No opinion on it.
I think, I share the same sentiment as Neil there, just really broadly. We haven't really looked at it, but I think that it's, it seems to be a system that's worked so far. But on issues over the next 90 to 180 days, I think that, you're going to see multiple committees within Congress sort of go back through and look at what the FCC's done on net neutrality and whether or not they overstepped their bounds really in regards to the rules that were promulgated last month. I agree with Neil. I think that the Performance Rights Act is something else that's going to be looked at again. My boss was a part of the discussions that took place last Congress on it, and I think that there was a significant shift, though, by the end of the Congress, just to the fact that at least in the tentative agreement that they had, there was a recognition of the right, at least from the broadcasters, at least what was initially out there. But that sort of fell apart towards the end. I think that we're also going to take a greater interest in the incentive auctions that the FCC is proposing as well to get back spectrum from the various holders of it. I think that it's really, I don't necessarily know how successful they're going to be with the current plan that they've put out there, just because when you look at the technologies that are being proposed as well, such as 3D TV and the rollout of 4G wireless and other ways that's already being, well, really 3D TV from a broadcast perspective, whether or not that coincides with the broadcasters and other groups giving back spectrum to the FCC for being re-auctioned, but at least, I think as well, they'll probably readdress the D block as well that really didn't move the last time it was put up for auction. And then again, specifically, my boss's committee is looking at IT reform, cloud computing, and just from contracting issues, ways of really improving the government's procurement policy.
Okay. Thank you. Any quick last comments here?
Very quick. I mean, Lawrence, more the person you should be asking in terms of the agenda in the House for the next 6 months. I will say just from the appropriations side, a lot of these issues, are going to be caught up in, in what are much more acrimonious issues about funding that are going to, obviously be playing out over the next, over the next couple months and then going forward for the rest of the year, which are really going to sort of dominate the appropriation cycle. So, I think these might, in some level be sort of swallowed up by all of that.
I'll just add quickly, I think you've heard that a lot of the issues we've talked about today have a strongly international focus or international component, or the complexities of dealing with trans-border transactions, or especially the nature of the internet. And so I think that's going to continue to be an important theme for a lot of different IP issues that we address.
Great. Carol.
Everything's pretty much been said. We all know that the Judiciary Committee has made anti-piracy and patent reform priorities. I expect that will continue. Those will continue to be priorities. And then this is a dynamic and changing industry, and so there are many more issues that will come up, that could come up, that the debate will continue to evolve.
Thank you. And I think Sylvia Syracuse has one quick announcement for us before we leave.
So just want to say thank you all for coming, and thanks to the panelists, and thanks to Drew Clark. And don't forget to fill out your surveys. We really value your input. And also keep in mind our February 8th IP event is China and Intellectual Property with the China Embassy Attaché, IP Attaché. We're very excited about that. And we want again to thank our sponsors, the National Cable and Telecommunications Association and Public Knowledge. Thanks again to everyone for coming.